he knows what's about to happen. And I'm not going to try and defend the
indefensible.
He
knows.
Yeah.
I mean, but I don't know what happened. That's what I want to find out. Mr. Wiggins, how's jail?
A man on bond for assault picks up not one, not two, but 5 new felony charges, including shooting at a car full of teenagers and grazing a 17-year-old girl's arm. We're talking for aggravated assaults, a deadly weapon charge, and bond violations that stack up like a criminal resume from hell. The judge is about to drop a $250,000 bond hammer, and honestly, this defendant is lucky to be breathing free air right now, because 3 inches to the right could have made this a capital murder case. Buckle up, because this courtroom hearing goes from 0 to absolutely insane in record time.
How's jail? Is it good? All right. All I know is that we've got you on an assault of a family member, right? All we ask you to do is be good, right? It's fine. It's not a big deal. You know, I see that you've picked up an aggravated assault with a deadly weapon, violation of a bond condition or assault, stalking, another aggravated assault of a family member, and then another aggravated assault with a deadly weapon. So you picked up 1, 2, 3, 4 aggravated assaults, and then another felony violation of a bond condition. I don't know what happened. So I'd like to know, because, you know, I need to make sure that Harris County is protected as well. And it seems to me that it may be an issue. So please, what happened?
Let's pause right here, because this is absolutely wild. Mr. Wiggins was out on bond for assault of a family member, which is already serious. And all he had to do was stay out of trouble. That's it. Just don't commit crimes while you're waiting for your court date. Simple, right? Wrong. This man somehow managed to rack up 4 aggravated assault charges, including 2 with a deadly weapon, plus stalking and a violation of bond conditions. That's not just bad decision-making. That's a masterclass in self-destruction. In Texas, aggravated assault is a second-degree felony carrying 2 to 20 years in prison, but when you add a deadly weapon, it can be bumped up to first degree, which means 5 and 99 years or life. And he's got multiple charges. The judge's tone here is telling. How's jail? Because he already knows his defendant just threw away his freedom. The prosecutor is about to lay out exactly what happened. And trust me, it gets so much worse. The judge isn't even trying to hide his disbelief at this point. When a judge asks what happened, in that tone, you know the evidence is damning.
First, I'd like the question now that DVD filed a motion to revoke and raise. They're asking for $100,000 bond because of the sheer amount of violations.
Okay.
Add the injury to the complainant and threat to the complainant and the safety of the community. On the newest, on the ag assault ending in 500, August 5th, 2024, deputies responded to an ag assault call. It started as a call for speeding. Both the affiant and the sergeant, his sergeant, observed a gunshot in the back window of a white vehicle. The affiant met with all 3 complaining witnesses that were inside the white vehicle. All the victims are minors. The complainant JT stated that they were at DT's house. Complainant JT stated that he observed the defendant drive off in a gray car, and she observed the offender get out of the driver's side of the car, pull out a black pistol, pointed the pistol at the complainant's inside of the vehicle. Complainant JT then stated that she attempted to flee the area and had complainant AM in the right front passenger and DT in the back seat. JT, the driver, stated she sped off, and the offender fired 1 shot at the white vehicle as they were speeding.
So he fires off a shot to the vehicle.
Right. Yes, Your Honor. She stated that she was speeding above the speed limit because she and all of the other complainants were in fear of their lives and believed the offender wanted to kill them. She stated that they were trying to get away from the offender, and the offender was following them in his vehicle. And she said the offender left the location, got out of his. She had stated that when the offender left the location and got out of his vehicle, she realized she was grazed by the bullet in her upper right arm that was shot through the car. The officer observed the injury to the complainant.
So she was shot in the arm.
Yes, Your Honor.
Raised. It wasn't direct hit. It was a slight.
She's 17 years old, Your Honor.
And that is
The same complaining witnesses in our case.
was the driver.
I guess we should be lucky that she's not dead. because probably, 3 inches to the right. Could have been the head, could have been the heart. Then you'd be looking at a capital murder charge. Life without parole.
Hold up. Let me make sure we all understand what just happened here, because this is absolutely chilling. Mr. Wiggins got out his vehicle with a black pistol, pointed it at a car full of teenagers, and fired a shot as they were trying to flee. The bullet went through the back window of the car and grazed a 17-year-old girl's upper right arm. She was hit by a bullet while trying to escape. All 3 victims are minors, kids, who were in such fear for their lives that the driver was speeding to get away while Wiggins chased them in his vehicle. This isn't a heat-of-the-moment scuffle. This is attempted murder behavior. The judge's comment is bone-chilling. 3 inches to the right could have been the head, could have been the heart, and you'd be looking at a capital murder charge, life without parole. Think about that. 3 inches. The difference between aggravated assault and spending the rest of your life in prison with 0 possibility of parole. And here's what makes this even more terrifying. The prosecutor mentioned this is the same complaining witness from another case, meaning there's a pattern of targeting these specific victims. This wasn't random. This was targeted violence against teenagers. How do you even defend this?
The VPO stems out of the same transaction. The other ag assault actually predates all of the newest ag assaults from 2023. We can read that one too.
Okay.
If you wish.
Okay. On October 15th, 2023, the complainant's officers, or the complainant's mother, Miss Alexander, stated that on October 15th, 2023, a defendant was passing by a Jack-in-the-Box, decided to stop there. The complainant stated as he was walking through the front doors, the defendant approached him with a brick in his hand, and the defendant threw the brick towards his head and moved quick. And he moved his head quickly to one side, causing the brick to hit him in the left shoulder and left bicep. The complainant in this case is DT, the brother of JT. Okay. It's not at all.
Wait, it gets worse. A year before the shooting incident, in October 2023, Wiggins assaulted DT, the brother of JT, the girl who was driving the car when she got shot. This wasn't some random encounter. Wiggins saw DT walking into a Jack-in-the-Box, approached it with a brick, and threw it at his head. DT had to dodge, and the brick hit him in the shoulder and bicep instead. So let me connect the dots here. Wiggins assaults a brother with a brick in 2023. Then a year later shoots at the sister and her friends in 2024. This is a clear pattern of escalating violence targeting the same family. First it's a brick, then it's a gun. First it's assault, then it's attempted murder. This demonstrates premeditation and targeted harassment. The charges stem from the same ongoing conflict, which makes it even more serious in the eyes of court. When judges see patterns like this, they don't see isolated incidents. They see a dangerous individual who's escalating and needs to be stopped before someone ends up dead. The question isn't if someone will die. It's if this defendant isn't locked up.
I don't understand what anger. I'm not asking you whether you did or not. I don't really. But I don't understand what anger would cause someone to do such things that where you would be living in a 6x9 box for the next 5 to 7 years, I'm going to find, Mr. Wiggins, that you are an extreme danger to the community. And I'm going to set your bond at $250,000. If you do bond out, you will be required to have a GPS monitor. You will be required to go be under home confinement, not to have contact with any of the complaining witnesses in our case. Do you understand, Mr. Wiggins? We're lucky that it's only a graze because it could have been a lot worse, and I just, there's always two sides to a story. I get it. right? And there's always video, there's always some kind of evidence out there, and we'll get it. The problem is that the allegations are pretty bad, and there are witnesses that put you there, and not just one. But how many people in the car? Three?
Three, that's why there's three separate charges.
The judge just dropped the hammer. And honestly, Wiggins should be grateful it wasn't worse. A $250,000 bond. That's $250,000. To put that in perspective, the prosecution initially asked for $100,000, but the judge doubled it and added another $50,000 on top because he found Wiggins to be in extreme danger to the community. And even if Wiggins somehow manages to post that astronomical bond, the conditions are brutal. GPS monitoring so authorities know exactly where he is at all times. Home confinement meaning he can't leave his residence except for approved reasons, and absolutely no contact with any of the victims. The judge's reasoning is powerful. I don't understand what anger would cause someone to do such things that would have you living in a 6x9 box for the next 5 to 7 years. He's acknowledging that Wiggins is about to spend significant time in prison, and he's genuinely baffled at the self-destruction. Notice the judge also mentions evidence. There's always video, there's always some kind of evidence out there, and we'll get it. That's a warning that even if Wiggins tries to claim innocence, the prosecution will build an airtight case. With 3 eyewitnesses in the car, that's why there are 3 separate charges, and physical evidence like the bullet hole and the victim's injury. This case is pretty much open and shut.
So like I said, if you want to stay on, let me know.
Yes,
If
Your Honor.
not, you tell me what date you want to set it for. Looks like the felony court set for 9/24.
Yeah,
I'm at your mercy.
regarding this, Judge, can I have a week from today?
Absolutely. So they're hired onto your case now. I don't know if they're going to want to stay on your case because it's a lot of baggage, right? And it's a lot. So if they want to stay on your case, we're happy and welcome to have you on the case. If not, they're going to withdraw and then I will appoint you a lawyer.
Let's talk about something interesting that just happened. The judge acknowledged Wiggins as a lawyer, but suggested they might not want to stay on the case because it's a lot of baggage. That's judicial code for this case is a nightmare to defend. And honestly, what attorney wants to defend someone who shot at teenagers and has 4 separate aggravated assault charges? But here's my question for you. Does everyone deserve legal representation, even when the evidence seems overwhelming? The Sixth Amendment guarantees a right to counsel, but private attorneys can withdraw from cases if the relationship breaks down or if they're ethically uncomfortable. If Wiggins' lawyer withdraws, he'll get a court-appointed attorney who has to represent him regardless of how difficult the case is. So here's what I want to know from you in the comments. Do you think Wiggins deserves a vigorous defense given the severity of the allegations and the multiple victims? Or do you think some cases are just too clear-cut? And what about those teenagers? They're going to have to testify and relive this trauma. Do you think the system does enough to protect young victims in violent crime cases? Drop your thoughts below because this raises serious questions about justice, representation, and how we balance defendants' rights with victim safety. All right, let's bring this all together and break down what we just witnessed. Mr. Wiggins came into court on an assault of family member charge and somehow managed to pick up 5 new felony charges while out on bond for aggravated assaults, including 2 with a deadly weapon, plus bond violation and stalking charges. The most serious incident involved him pulling a gun on 3 teenagers, chasing them in his vehicle, and shooting at their car, grazing a 17-year-old girl's arm. The judge found him to be an extreme danger to the community and set bond at $250,000 with GPS monitoring and home confinement if he manages to post bail. This case demonstrates a clear pattern of escalating violence, starting with a brick attack in 2023 against one victim's brother, then progressing to gun violence in 2024. The victims are all minors from the same family, suggesting targeted, ongoing harassment that culminated in attempted murder. The judge's commentary was particularly striking, acknowledging that 3 inches difference in the bullet's trajectory could have turned this into a capital murder case with life without parole. The prosecution has 3 eyewitnesses, physical evidence including the bullet hole and victim's injury, and a clear pattern of behavior, Wiggins' own attorney may withdraw due to severity and complexity of the charges. The legal reality is stark. With multiple aggravated assault charges, Wiggins is facing potentially decades in prison, and the judge has already indicated he expects a 5 to 7 year minimum sentence. This is a textbook example of how violence escalates when not stopped early, and why bond conditions exist to protect communities. If you found this case as shocking and disturbing as we did, make sure to smash that like button, drop your thoughts in the comments, especially about whether the $250,000 bond was too high, too low, or just right. And don't forget to subscribe and hit that notification bell for more intense courtroom breakdowns where we analyze the evidence, legal strategies, and real-world consequences of violent crimes.